Welcome to Joint Session Diverse Voices in New York State Cannabis, the podcast where policymakers, legislators, thought leaders, licensees, and advocates come to discuss the evolving landscape of cannabis in New York and beyond. I'm Herb Boisbeau, former Director of Operations in New York's Office of Cannabis Management. Each episode, we bring you in-depth conversations with key voices shaping policy, business, and advocacy, plus expert insights on the latest developments impacting the industry. And now for the episode.
Welcome to episode 21 of season 2 of Joint Session. This is Herb Boisbeau. In this episode, we'll speak with Alex Norman, owner of Budega in Park Slope, Brooklyn, Fernando Peña, owner of Late Bloomers in Ridgewood, Queens, as well as attorneys Fatima Afia and Benjamin Ratner. But first, as always, let's take a spin around this week's news. While New York's Office of Cannabis Management's disclosure this week that it had incorrectly measured the distance between dispensaries and schools was the biggest story this past week, there were a few others I'd like to mention before returning to OCM's proximity correction news. Researchers at the National Institute of Standards and Technology and the University of Colorado found that not only is THC present on a person's breath after smoking cannabis, but the same is true for edibles. This study supports the idea that multiple breath measurements over a period of time could be a way to use a breathalyzer to detect cannabis use, regardless of how it's ingested, said Tara Lovestedt, a NIST chemical engineer working on the Cannabis Breath Research Project. However, devices will still need standards to ensure that they are accurate and used correctly, standards that don't yet exist. These findings were published in the Journal of Analytical Toxicology. The nation's largest anti-legalization group, Smart Approaches to Marijuana, has launched a 6-figure ad campaign to oppose cannabis rescheduling. The ads, which will air on Fox News and Fox Business Network, kind of preaching to the choir, say that moving cannabis to a less restrictive category would benefit Chinese and Mexican cartels, as well as big cannabis, and harm public health. President Trump and Republicans are the focus of Sam's push, and the group also frames rescheduling as Biden's politicized proposal in an announcement about the ad campaign, which is called No Schedule 3. On Friday, August 1st, adults 21 and older in the state of Delaware were able to legally purchase cannabis at one of 12 licensed retail locations. All retailers were previously licensed to sell medical cannabis. Ahead of the program's launch, Governor Matt Meyer and Josh Sanderlin, the marijuana commissioner, toured a cultivation facility in Milford. The two got a first-hand look of First Day Compassion, owned by MariMed. Meyer and Sanderlin also met with cannabis students that are part of Delaware Technical Community College's First Cannabis Workforce Training Initiative. The legal market is expected to generate $40 million in annual revenue. Congratulations to Delaware. The California Department of Public Health held a public hearing last week to take comment on its proposal to permanently ban intoxicating hemp products. Governor Gavin Newsom first called for an emergency ban in September, and the department released proposed regulations in June to make the ban permanent. The regulations, which require hemp products to have no detectable amount of total THC, is an effort to protect the public health and safety from injury, illness, or death, according to the department's proposed rulemaking notice. A ban is estimated to result in $602 million in lost revenue for California businesses in the first year, a total loss of $3.14 billion in 5 years, and a loss of tens of thousands of jobs. In North Carolina, an advisory council on cannabis held its first meeting early last week to get the ball rolling on what legal cannabis might look like in the state. Governor Josh Stein created the council to recommend a framework for legal adult use sales in the state. Let's go North Carolina. In May, a Pennsylvania Senate committee rejected a House-passed bill that would have legalized adult-use cannabis and put the state in control of retail. This week, Representative David DeLozo introduced the idea again via a new bill, HB 1773. DeLozo's proposal joins a steadily growing list of adult-use proposals in the state where, despite support from 2 consecutive governors, lawmakers, specifically Republicans, have consistently rejected legalization. Returning to New York State and the chaos that unfolded as more than 100 cannabis shops, mostly in New York City, were told that they may have to find new retail spaces. The New York Times ran not 1 but 2 stories on this issue. Ashley Sato reported that OCM disclosed that they had incorrectly measured the distance from the entrance of the potential dispensary to the entrance of a school in contravention of the Marijuana Regulation and Taxation Act, which required, according to OCM, that the distance be measured to a school's property line. The Times reported that the affected businesses included 60 operating dispensaries, 45 others that are getting off the ground, as well as 47 applicants who were required to secure deeds or leases in advance. In the second story, Southwell reported on the intense backlash from license holders and lawmakers. Southwell revealed that the idea of measuring the 500-foot buffer zone from a school's property line had been proposed in 2022, but regulators altered the standard in response to concerns that New York City would be left without enough stores. The change was detailed in revised regulations issued in May 2023 that had to be reviewed by the governor's secretary. Now, to those not familiar, the governor's secretary is not her administrative assistant, but rather is more like the first deputy mayor in New York City. So the regulations were reviewed by Hochul's secretary, her counsel, and the state budget director before they were adopted. The legislators most identified with passage of the MRTA were caught by surprise. Senator Liz Krueger said in an interview that she was perplexed by the administration's decision to sound alarms before consulting lawmakers. She said that the problem sounded easy to fix and was unclear why it had suddenly become an issue. I wrote the law, and I'm not sure that you did make a mistake, Senator Krueger said, referring to the agency. Crystal Peoples-Stokes, the leader of the Assembly's Democratic majority and the driving force behind the MRTA, said that she saw nothing wrong with how regulators had applied the 500-foot rule. She said lawmakers had given the Cannabis Agency broad authority to interpret the laws as it saw fit to accomplish the goal of creating a robust market. As for the agency, the acting executive director, Felicia Reed, said in a statement this was a difficult but necessary decision to bring the office's practices into full alignment with cannabis law. I recognize the impact this correction may have on licensees and communities, but I want to be clear, our success as a regulatory body is tied directly to the success of our licensees. Thanks to Cannabis Wire for the news. Check out Cannabis Wire at cannabiswire.com. Today, we have a panel to discuss the newest issue roiling the New York State cannabis world. I gave a little bit of an update on the news segment, but now we'll speak with two attorneys about the Office of Cannabis Management's recent proximity correction. Welcome. Fatima, please introduce yourself and then we'll go to Ben.
Sure. My name is Fatima Afia. I'm an attorney at Rudick Law Group, PLLC. We are based in Manhattan, and I have been practicing in the cannabis industry since 2017. Initially as a litigator, I was part of the legal team that brought a lawsuit against the DOJ and the DEA arguing against the unconstitutionality of Schedule I classification of cannabis. And from there, I pivoted most of my practice from litigation to transactional work in the industry, first advocating for a social equity expansion, so to speak, in the state of Massachusetts back in 2018 or 2019, which my advocacy led to a expedited review process for minority and women-owned businesses in that state. And then from there, I really did pivot just pretty much my entire practice over to cannabis and cannabis-adjacent industries, mostly transactional, commercial transactions, corporate governance, advocacy, and regulatory compliance work. Thank you so much for having us.
Thank you very much, Herb, for having me on your podcast. My name is Benjamin Ratner. I founded the cannabis practice at my law firm, Tramelli & Wood, LLP, based in White Plains. We perform a suite of services, everything from licensing and advice relating to cannabis business structuring, real estate, and build out, to when things go wrong. And we are a firm that does engage in cannabis-related litigation. I've been practicing law for 15 years and in the cannabis space exclusively in New York since the enactment of the MRTA back in 2021.
All right, so this has been quite a week. Last Monday, Fatima, what exactly did OCM announce?
So OCM announced that it apparently had been incorrectly interpreting the MRTA as it applies to the 500-foot distance rule between schools and dispensaries. So up until Monday of last week, OCM had been measuring the distance between schools and dispensaries by door to door. So the main entrance from your dispensary to the main entrance of the nearest school. And what they're saying is that that was an incorrect method by which to measure. What they should have been doing is measuring from the dispensary's door to the nearest point of the property line of the school grounds, as that term school grounds is defined under the education law. And that really is a massive change in interpretation. It sounds like it's just semantics and it's just a couple of changes in words, but it really does open up a lot of dispensaries, as we've already seen, to not being in compliance because of that difference in interpretation.
All right, Benjamin, I know you've taken a look at the regulatory history. So, what was the difference between the legislation and the regs, and how did that come to be?
Sure. So if you look at the MRTA, it requires that no dispensary be located within 500 feet of a school, as that term is defined in the education law. And for that, you look at Section 72, sub 6 of the MRTA. Then you look at the education law, and under, I believe it's Section 409, a school includes school grounds. It's not just the building. It's it's the parcel on which the school sits. And when back in December of 2022, when OCM first promulgated the proposed adult use regulations, they adhered closely, in fact, identically, to the definition of what school grounds meant. And they were proposing in the measurement of distances between schools and dispensaries that those distances would be, in fact, 500 feet from school grounds. Mm-hmm. Now, this was met with a lot of public comments seeking to shorten the distance and, in fact, change the definition of what school grounds meant under the regulations. OCM, in response to those public comments, said, we can't, in effect, we cannot change what the law requires, and the definition has to remain the same. So they kept the definition of school grounds as set out in the education law, which they should have done. Mm-hmm. But what they then did is they changed how they measured the distance between the retail dispensary and the school in a way that, exactly as Fatima described, where it would be main entrance to main entrance, mm-hmm. which disregards the property line of the school grounds. So there was an inconsistency in the regulations between the definition of what constituted school grounds and how you actually measure the distance between the dispensary and the school. Mm-hmm. And unfortunately, that resulted in a lot of people measuring door to door instead of going back to the definitions and saying, okay, or back even to the MRTA and then back to the education law and measuring it as required by the statute.
All right. So, and Fatima, so what's the practical impact of this change?
So, I mean, it's pretty massive. Already we've seen over 150 dispensaries that have been named to date that are now currently in violation of this newly interpreted version of the MRTA because, as Ben mentioned, having to go to the nearest point of the property line of school grounds, we're not talking about a single building. I mean, there are grounds that are acres long and that have multiple buildings on them. And so having to go from the front door of the actual school building versus the nearest property line of the school grounds, which could be acres long, that is a massive difference, particularly in a place as congested and as tightly configured as New York City. Mm-hmm. And if you notice on that list of dispensaries that have already been impacted, the vast majority, I think someone estimated that we're at like 89% or 90-something% of those dispensaries impacted are all in New York City, which is not a coincidence. It's because we are obviously going to be tightly compacted, given that there are 8 million people living in a relatively small city in terms of geographic size, right? And so that was actually one of the reasons that OCM did do an about face in 2023 when we did get all those public comments, and there was already some controversy and debate surrounding how we should measure the distances. The reason they, at that time, reverted to this door-to-door distance was because people were saying, if we do the true school grounds property line measurement that the MRTA seems to be clearly saying we need to do, well, then we're not going to have enough dispensaries in New York City because you're going to basically box out everybody. There are schools everywhere. And so that was the reason why OCM initially did do that about face, and now we have another about face 2.5 years later.
And it's not just licensees, right? This also impacts those that are on queue to open, right? They may have the dispensary built out, just waiting for that final inspection before.
Yeah, we have about 40-something applicants to date that have been impacted, and then over 100 licensees to date that have been impacted. And those numbers are probably going to increase, I would say, exponentially.
And just to add to Fatima's point, the list of dispensaries impacted, it's a dynamic list. It's changing. Last week, it seemed like it was 47 applicants that are impacted. OCM's website now says 44. I think, and they're also saying that they're still trying to figure out the impact on 6 additional dispensaries as of the website last night. One other thing to just keep in mind is that, the retail dispensary regulations also apply to micro businesses that have retail authorization. And OCM has made no mention whatsoever so far of any impact on any micro businesses that may have retail authorization. They're not included in the numbers. We don't know what the impact is going to be. So while this is a monumental change, the scope of it has yet to be fully felt.
And I want to make another point. So what's interesting is if you look, I haven't looked at the OCM website today. And as we're saying, this is very dynamic. So today it could be different. But as of the last time that I checked the OCM website, which was late last week, there was no mention on the website about anything other than the fact that they were changing the way that they were measuring the distance as a straight line measurement from dispensary door to property line of school grounds. That's all they said in terms of what the violation of the MRTA was that they had identified, which was requiring them to now make this policy change, right? But if you look at some of the notices that clients are receiving, it also, at least in a lot of the notices that my clients received, it also specifically addressed the fact that there is a provision in the MRTA, in the regulations, that says the 500-foot rule applies only to buildings that are exclusively used as a school, okay? That is a very, very important regulatory provision because now OCM is saying that regulatory provision is in direct conflict with the MRTA and is no longer valid. So now we're not just talking about places that are exclusively used as a school and measuring the property line of the school grounds on which it sits. We're also talking about buildings that can be used as a school and something else, maybe a community facility. I mean, there are so many, particularly I think of Jewish schools, it's so common for them to not only use them for their school purposes, but also for community-related events and facilities. And in those instances in the past, those buildings would not have been counted as schools for purposes of measuring the 500 feet. So that is a huge other issue that's not even on their website when someone is just very quickly looking for information directly from the source. They have to get a specific notice to be told that this is also why you're now being impacted because the location that you thought was being used for multiple things, that now actually is part of the calculation. I would also say that I had not heard anything from OCM about this, but I wouldn't be surprised if in the coming days they continue to elaborate on this new interpretation. And they say, if you look at the school grounds definition in the education law, it doesn't just include schools, not just primary and secondary schools. It also includes preschools. It also includes nurseries. The nurseries is a big one because I can tell you, many of my clients, many of other people's clients they were not including nurseries in their calculations when they were checking for proximity protection. They were checking exclusively for schools and as I said, buildings exclusively used for schools. But they weren't even thinking about daycares and nurseries. And so OCM hasn't said anything yet to clarify if they're now going to be including that in their 500-foot distance requirement. But if they're being really strict, as they're claiming to be, about their interpretation of the MRTA, if you look at the definition of school grounds, it includes nurseries and preschools.
Right. And in particular in New York City, in the last mayoral administration, when they had the program 3K for all, it tremendously increased the number of spaces that are being.
Yes, because so many, I could tell you as a parent, my child almost went to a daycare that also had a 3K program through the DOE.
All right. So Benjamin, what is OCM's proposed fix to this?
Well, OCM's proposed fix is an interesting one. They're basically saying that if you're a retail dispensary and you're already open, you can stay open, you can continue to operate, and you can submit your application for renewal. However, it appears that OCM is going to slow walk approval or denial of your renewal application until they know what the New York State Legislature is going to do to address this issue. It sounds to me like OCM and the governor's office will be lobbying the legislature to change the language in the MRTA as to how to measure the 500 feet between schools and dispensaries. And most likely we won't know the outcome of that until spring of 2026. But in the meantime, retail dispensaries that are operating face a great deal of uncertainty because they don't know whether they're going to be able to continue operating at the location or whether they're going to need to move locations, which itself is problematic for a large number of reasons, including finding another compliant location, the time that's involved, the money that's involved, and other people establishing locations that may be compliant and therefore boxing them out. So there's, for the people that are operating, there's some reassurance, but I'm not so sure that it's a great solution. It would be better if the legislature were back in session this fall. We could enact the legislative fix and gain some certainty that way. As for the 40 some odd applicants who have been told their licenses or their locations are no longer viable, OCM is essentially telling them, find a new location and perhaps you can get up to $250,000 as compensation, which depending on where they are in the process of building out, is likely nowhere near enough to compensate them, not just for the leases and the build out expenses, but also the professional time and the time that they've lost in terms of getting open.
Right. And for those people who don't know, the New York State Legislature is a part-time legislature. So they're out of session now. They return in January. So the hope is that they will take this up early in January. And not return early. That would be the ideal thing for them to return early to deal with this one issue, but it doesn't appear they're going to return early. So now the $250,000 per licensee, how would that, be of use to a person who has a dispensary that may need to move now?
Well, let's be clear about that. The $250,000 is not for people that are already open. It's for people who have applied and now need to relocate. It can be used to help defray some of the costs, but we don't yet know what strings are attached to that. It's likely that if you're going to receive that money, you're going to have to agree not to sue the state of New York or the OCM. And
100%.
Given the magnitude of the error, I don't know that everyone is going to agree to that. In fact, I suspect most people will not agree to that.
Yeah, lots of folks are already lining up, talking to attorneys, figuring out their litigation strategies. I mean, $250,000 for many, many people who have not opened their doors yet, but have already started build out, for example. I mean, that is just a drop in the bucket compared to what they've invested. I mean, build out costs alone can cost you close to $1 million. That doesn't include the costs that you've already invested into your lease negotiations. If you had to pay any sort of holding fee in the interim, I mean, landlords have gotten, particularly greedy in this particular industry because they know that the stakes are really high and they understand the nuance in the law, given federal prohibition. And so, landlords do charge like premium rates not just for your rent, but also for any sort of holding fee before you actually commence your lease. And so we don't know the extent to which people have invested in these properties, even if they're in relatively early stages of their application submission, right? Because what's also interesting is OCM issued supplemental guidance to clarify that the applicant relief fund was not open to licensees, right? As Benjamin just noted, people who are already operating. But what's interesting is they said it's for applicants, not for licensees. OCM didn't specify what that actually means, though, right? Because technically, somebody who hasn't opened yet but has gotten their final license to operate is a licensee, right? And so for a while, we didn't even know if those people who had not yet opened their doors but did have a license would not be eligible for the funds. It does seem, according to the most recent New York Times article that came out on Saturday, that at least lawmakers in Albany are under the impression that if you have not opened your doors yet, you would be eligible for that fund. But again, if you're like 80% of the way through your build out, which is the case for a lot of my clients, $250,000 is nowhere near enough. And if OCM is going to require some sort of waiver to be signed in order to access those funds, which is likely the case, we don't know that clients are necessarily going to think that that's sufficient to make them whole. And so they may still seek litigation, particularly if we don't get any sort of real tangible answers on legislation.
No, and I would agree that a waiver in exchange for the funds makes sense from the state perspective. So what are you advising your clients at this point in time?
I mean, I'm kind of telling people to work on dual tracks, right? Like if you are already heavily invested in the property in which you're located and you would be eligible to be grandfathered in, presumably, I think you need to at least just keep that alive. I don't know that I would invest so much into that process either, because if it turns out that we either don't get that legislation or it takes too long and you can't wait for it, or for some reason, the way the legislation is drafted, you're not eligible to be grandfathered in, you wouldn't want to keep investing in something that's not going to be able to be grandfathered in. But at the same time, you want that opportunity in your back pocket. And you also should be looking at additional properties in the event that you do have to relocate. So it's kind of like working on dual tracks.
Yeah, I would agree with Fatima. I mean, you got to remain flexible given the environment. There's a tremendous amount of uncertainty. We've only just begun to see what the implications are. And I do want to jump back for a moment to this $250,000 applicant relief fund, because one of the expenses that we haven't touched upon is the cost of the actual lease. And so, as many people know, when you sign a lease for a retail dispensary, it's a conditional lease. It's conditioned upon receipt of approvals, often site protection or proximity protection. At that point, the lease goes hard. And if you're an applicant and you've received proximity protection, now you're locked into a lease for 5 years, 10 years at tens of thousands of dollars a month, and you can't get out of that lease. $250,000, forget the build-out costs, forget the professional fees. That's not going to cover a lot of the lease obligations, all of which are due if you break the lease, many of which are personally guaranteed. So this is a real catastrophic event for a lot of people who put everything on the line to open a dispensary.
Now, if the lease didn't become a hard lease, as you said, until they got the site approval, if that site approval is withdrawn, shouldn't it revert back? I mean, I guess that would be the argument.
It depends on the language in your lease, right? So, I always advise clients, if they can, to push for permitted termination language, which means if there's a change in the law, if there's something that happens that's totally out of your control, you're in no fault whatsoever, and it prohibits you from operating at that location, you're able to get out of the lease without being penalized. But not all landlords will agree to that, right? And then lots of clients just don't listen. They really like a property and they fall in love with real estate, which they should never do. So then it happens. And they get excited and they just want to move quickly because they have invested so much time and money already and they don't want to drag their feet any longer. And so they jump into things. And so we don't know what the language is of each individual business's lease. Some people are going to be on the hook for tens of thousands, if not more.
Now, is there any other recourse for challenging the new measurement? I've heard of one, dispensary owner who says even with the new measurement methodology, that they believe that they're still within the 500 or outside of the 500-foot, but that the state is saying they're within the 500-foot, that they're counting property that does not actually belong to the school.
Well, then that's up to the licensee to convince the state, and it may take all the way through renewal and a showing by the licensee that, look, we've done a survey and here's the property line for the school grounds and here's what our surveyor measured to the entrance of our dispensary. But do you as a dispensary really want to engage in an uncertain and lengthy battle with the state, likely to drag out over the next 6 to 9 months minimum?
I mean, I would urge anyone who, is pushing either for a new location now or pushing to stay in their current location because they believe it still is compliant despite what OCM is telling them. Everyone really needs to do their own due diligence on their property measurements now in line with this new way of measuring. And make sure you have documented evidence to support your position on why you're not in violation of the new method of measuring.
Absolutely.
Because
that's absolutely correct.
we unfortunately just don't, I hate to even say this, but we don't have the confidence in OCM now to necessarily just take everything that they say, like the Holy Grail. We do have to really think twice now about what it is that they're saying, because they've admitted that they have been incorrectly measuring things for 2 years. And even their local maps, you cannot rely on those because those are based upon the prior method of measuring.
And not only are the methods of measuring wrong on the local maps, the local map, which is a good shorthand tool, does not substitute for doing your diligence and actually learning where is the boundary of the school ground. Is this in fact a school, and it may now be irrelevant, but you can't tell from the local map if a building is exclusively used as a school.
You need to go to your county clerk's office.
Correct. It's all about diligence and going back into what the law says and making sure that you're complying with the actual implementing the legislation. And if there's an inconsistency of in the regulations, which there was in this instance, you need to work through it and understand what the risks are if an interpretation of the regulations changes. And unfortunately, we've seen that play out, and we're going to see the ripple effects over the next 6 to 9 months, if not year.
No, it's true. Outside of New York, a school may have a park or a field attached to it. In New York City, a lot of times the parks or fields attached to a school are not part of the school. They're actually Department of Parks. So they may have to really dig in and get that background. So Benjamin, what's next? What should licensee applicants, what should they be doing right now?
The licensee applicants right now, it kind of depends on their individual circumstance. Someone who has just received a license with a site approval and has not yet begun build out, the most practical and cost-effective thing to do, find a new location. Not easy, not easy, especially in the 5 boroughs, but it is realistically the easiest path to opening. People that have built out and are close to opening, there are several attorneys I know who are putting together litigation, and those applicants or potentially licensees, depending on whether they've paid the final license fee and are awaiting their final compliance inspection, they may want to engage in litigation, or they may want to take a wait and see approach. But I think the most important thing that we can do at this point is stay flexible, keep informed, and evaluate all of the available options, because what's right for one person or one dispensary is not necessarily going to be right for another dispensary, right? Going back to the discussion that we just had about the leases, if your lease contains language that allows you an out in the event of a change in the law, that you may be able to exercise that and relocate. On the other hand, if you're now locked into a 10-year lease, that changes the calculus quite dramatically. So again, it's flexibility, staying on top of what the developments are, and evaluating all your options dispassionately. Don't fall in love with property.
All right. Now, we talked a little bit about the New York Times articles this past week. Some of the lead legislators on the MRTA, the Marijuana Regulation Taxation Act, spoke in those articles. And one of them said, that she's not sure whether OCM really did anything wrong. They didn't tell us why that they should have come to us first. And another of the legislators said, that the legislature purposefully gave OCM broad discretion in drafting their regulations. Now, in your opinion, did OCM, sort of overreact when they discovered this, or did they overcorrect?
I think they overcorrected. I think obviously an agency that believes that they are not in compliance with the enabling statute does need to make sure that they are compliant. However, I think the manner in which this was announced, the fact that they are applying it retroactively, and the fact that they're applying it retroactively without a solution already in place. They're talking about lots of solutions, right? They're talking about this applicant relief fund. They're talking about a potential legislation change, grandfathering in, or maybe just changing the MRTA altogether, amending it so that they could make it door to door and be in compliance with the law, right? There's like a few different things that are being proposed here. But they don't have any of these solutions in place yet. And so what they've done is they've caused panic and chaos because they've announced that they are acknowledging that they are in violation of the law. They don't know how yet they're going to fix it. They've come up with a few ideas, but they don't have anything in place to actually fix that mistake that they've made. And now essentially, until they come up with those fixes, it is the applicants and the licensees who are going to suffer for OCM's supposed mistakes. So to me, that is not the way to ensure confidence in the market. It is not the way to ensure confidence in the system. There were already a lot of people who felt aggrieved by the licensing process, by all the prior litigations that resulted in injunctions. It's been a really rocky rollout since we've started to open up the licensing process here in New York. And this definitely does not make people feel more confident or more trusting in the agency. And I think that that's really bad for everyone all around, including OCM itself as an institution, right? And so I think there were a lot of other ways to go about this, even if OCM genuinely felt that they were not in compliance with the law and needed to correct that. There were other ways that they could have done this. And just as the lawmakers in Albany said, they sort of felt blindsided because they were not told, apparently. I mean, this is what they're claiming. We don't know what happens behind closed doors, but they're claiming that they were not told in advance of the announcement that this was a problem. And according to some of the lawmakers in that article that you're talking about, Herb, they said it actually is an easy legislative fix, right? But yet all this chaos is now amongst us because that legislative fix is not real and tangible yet. We are still waiting on the timing of it. We also don't know the extent of it. We don't know if any sort of grandfathering in legislation will include everybody impacted. Well, because it could be that maybe they'll change their mind about this $250,000 grant, realizing it's not even enough money for everyone. And maybe they grandfather in everyone who's already impacted. But we just don't know.
Right.
And that uncertainty creates a lot of dysfunction.
Benjamin, my last question, and it's kind of based on is the notion, of this 500-foot rule in today's world, is that notion that kids are somehow going to be harmed by walking by a cannabis dispensary, is that outdated? You walk by these dispensaries, there's no display, there's no real, sort of promotional element. I walk by my liquor store, and there's displays with all kinds of alcohol. That's the question. Is this outdated? Do we even need this anymore?
In my opinion, it is outdated. OCM has gone to great lengths in the packaging, labeling, marketing, and advertising regulations to ensure that no cannabis products or cannabis paraphernalia can be visible, even in the dispensary window as you walk by. So, you're talking about having perhaps neon light up signs and displays in windows of liquor stores, and yet you can't show anything even remotely close to what liquor stores are able to display in their windows for a dispensary. So yes, I think that the distance requirement between schools and dispensaries is out of date. And broadly speaking, there's no studies have repeatedly shown no correlation between the legalization of cannabis and the placement of cannabis dispensaries and increased youth use of adult use cannabis products. So yes, it's outdated in my opinion.
I do want to note that right now, OCM is saying if you have your doors open already, we will give you a grace period, even if your license is coming up on expiration. And, there is the State Administrative Procedure Act that does allow them to provide you a grace period so that you could continue to operate with an expired license with legal protections in place. That being said, there's nothing being talked about with respect to your insurance, your banking. All those things do require an active legal license, right? So you might be legally protected for purposes of OCM enforcement, even if you have an expired license, but we don't know what that's going to mean for already operating businesses with respect to their insurance and their banking obligations. We also don't know what that means for federal enforcement, because for the longest time, the federal government has taken a very hands-off approach when it comes to state legal cannabis, so long as you're in compliance with your state law. This new administration that we're under right now seems to be reversing course a little bit, even with the businesses that are in compliance with their local laws, because they continue to be in violation of federal law. But what about businesses that now will technically be in violation of even their state law? We do not know what that means for purposes of almost selective federal enforcement. And so I do think that OCM lawmakers, they really need to take into consideration what it means to be putting businesses in a situation where they're operating with an expired license. Yes, they might be safe under OCM regulatory frameworks, under New York law, but what does it mean for banking, for insurance, for federal law enforcement purposes? And I worry that they're putting businesses in precarious positions.
So they may have to figure out a way of doing short-term extensions, right? So they could do rolling month-to-month extensions that sort of keeps them.
That would be a better solution, but that doesn't seem to be the one that they are pushing.
And you'd also have to figure out if they can even do that.
Right.
Via the State Administrative Procedures Act and the MRTA.
But if they're going back to the legislature in January for one fix, maybe this is something they can add. Reportedly, right, a simple fix that they couldn't come back for one day just to get.
Governor Hochul has the power to call an emergency session.
Absolutely. To conclude, best wishes to you both and obviously to your clients in the coming months. Thank you.
Thank you. Thank
you very much.
In our panel now, we have two dispensary owners from New York City. Alex Norman recently opened Budega in Park Slope, Brooklyn, and Fernando Peña, owner of Late Bloomers in Ridgewood, Queens. Welcome.
Thank you for having me.
Thank you for having us. Yes, thank you. Good to be here.
All right, so this has been obviously the biggest news in the New York State cannabis world this past week. So tell me from your perspective, like what happened? When did you receive notice, and what did you think?
Actually, somebody had given me a heads up like 2 days before that this was going to happen. I didn't really process it. I was starting to kind of get feelings of something like this happening even before the person brought it up to me, because somebody, I was talking to someone else that had a location. They were waiting for approval, and then they were telling me that, things were buzzing. And then I started thinking back. I'm like, wait, are they going to challenge these, proximity rules, because I could, in my mind, and I'm not a skeptic, but I could see something like this unfolding, but it just wasn't anything that, and Fernando knows, like, once the door, once you start running the store, like, you're so focused on just the day-to-day stuff that you can't really start, going back into all the things that are going on, with just, all the legal stuff and all the calls and all the monthly calls with CCB. It's just like, all right, we got to focus on the business, because it's just so many little things that you got to stay on top of. So I kind of really didn't like dwell on it or put too much time into it until, I actually got the letter, via email. And then it was just kind of like a kick in the gut. And so, I know that for me, when I applied for the card license, I literally went through 3 injunctions. One that happened while I was in the middle of my build out. And, at that point, I considered that my lowest point in this whole process. And then, when I opened, finally, it was, finally some kind of, just vindication of being able to get through it all. And then the letter, and it was just like, this doesn't never lets up. So, I think, a week has gone by, and we've had time, myself and my partner, time to process this. So, we're taking it one day at a time, and just, talking to, a lot of different people to see what they're doing, to kind of figure out what our move should be. We are fortunate, us, Bodega, is that we just opened 2.5 months, and, the letter said that, they're not going to force us to shut down, but that when it's time for renewal of the license, that there's a very good chance that we won't be able to renew our license, and we would have to, vacate our location. So, yeah, I mean, that's just, right now what the current, news, where we stand with that. And, it's just kind of, again, we have a little bit of time to see how this plays out without overreacting. But I know there's a lot of other folks that are on that list that are up for renewal, let alone the provisional licensees that are trying to get open, which I know exactly how they're feeling right now, because it happened to me in December. And so, all I can say right now, considering considering all the things that are happening, that I'm actually fortunate right now, because I have a little bit of time.
No, and thank you for that. It's exactly what we wanted to hear. Okay, Fernando, what happened when you got the notice?
Similar story, exactly what Alex was saying. I think that we knew Wednesday or the Thursday before we heard something that's going to happen like this. I didn't think that our location would be affected. We're a DASI location, right? So we had at least 3 state agencies involved in doing this build out and the location and everything.
So, and again, the DASNY is a dormitory authority of the state of New York. So you're one of the about 20 licensees that card licensees that actually open under a pretty controversial program.
Ridiculous program. If that wasn't enough, then yeah, I'm thinking no way. And then we got the letter on Monday, and my wife and I have been through this before. We had restaurants, we had a wine bar, we lost them both before COVID. We went through bankruptcy. It was a terrible moment. But I feel also that everything we've experienced with this whole process, with the OCM, with the state, I feel like we've been trained after 18 years of running restaurants for all of this. It's like these 3 things happen. And it's just unreal. Like I'm trying very, very hard to not let my heart come up to my throat, and trying to eat some. This is just so unreal, on top of like what our DASNY locations are basic. Mm-hmm. And our license is up in February
2026.
Yes. So we don't know. Like, And so we work every day. I work every day since we opened.
Yeah. Have you had any individual contact with OCM or, in your case, Fernando, with DASNY as well?
Let me tell you, when we opened, nobody has shown up here. Nobody from any agency, nobody showed up here.
Alex, have you had any contact with OCM?
Yeah, they called me 2 days after I got the letter, basically repeating what the letter said. And then, the one thing that I did ask was, would they be able to send me like their map or whatever they're using to determine how we're in violation? Because based on our measurements, we clear the straight line measurement by 520 feet. We're pretty confident if that's our measurement or if we're calculating correctly that we would be able to appeal. Now, the other catch is that there's according to the MRTA ruling, or whatever it's called, the education law, that it has to be 500 feet from the property grounds. As you know, Herb, because you live in the neighborhood, that basketball court, pickleball court, dog run, it belongs to the city parks department. But when we looked on the Department of Finance property portal, it shows that the parks department and the school share the grounds. So we don't know if OCM is looking at it like that, saying this is co-shared, and in fact, then that means that the school property line is that park is included in the property line of the park. That would be great to know, because then we know that we're clearly in violation. We'd be 350 feet from that property line, but OCM won't send us that to let us know, because then we would just basically save money and not have to spend money on a surveyor to tell us that something that we already know. Now, if it's 520 feet based on our measurements, or based on where we think the property line should be, based on some of the other maps that we've looked at, where the park is clearly cut off from that kind of half block that, Herb, separates the school from that park.
Right.
Then we would then, pay the $2,000-$3,000 to get the surveyor to officially tell us, hey, this, your dispensary is, 500 whatever plus feet from, from the property line. So, that I was a little frustrated with, and obviously a little annoyed. But, we're gonna see. We're trying to use as many resources as we possibly can, to not have to come out of pocket, because we just opened, so we still have a ton of bills to pay. We have payroll. My partner and I haven't even paid ourselves yet. We're making sure that our employees are taken care of and all the bills are taken care of. So it's not like, we could just fork over the money, or for that matter, just jump on and retain a lawyer to, fight this. So, that's kind of, where we are right now.
So what have you heard about the proposed fix, the legislative fix that they're talking about in January? So again, Fernando, if your license expires in February, let's kind of cutting it close.
What can I say? This is so crazy. I can't even imagine. I just want to be positive that the governor is truly upset about this. But didn't she sign off on this? I don't know. This isn't something she found out through an email on Monday either,
Right.
And also our thing expires in February. Okay. We have to pay federal taxes, right? And so last year's taxes pretty much equal the loan from the fund, right? So if we can't operate, I'm going to be stuck with $240,000 or so from last year's taxes. We operated this year. I'm going to be stuck with those taxes in a program that was supposed to benefit us and help us and not bring us harm. This is harming us.
Now you're a sublessee, right, of DASNY. So really the entity holding the lease where you are is not Late Bloomers, but DASNY. and then you have a sublease with Daz.
Everybody's getting paid except us.
Right.
Everybody's making great money, taxes, everything. And it's how do you, they required us to be business people with a business background. All of it seemed funky. And then how do you project? How do you do business when you don't know if you're going to be open? Like we're stuck.
Alex, the proposed fix, how does that sound to you?
I believe it when I see it. I mean, it makes sense on paper, right? But we know that has to go through a legislative process and people have to vote on it. And, we still, I think as we've seen in other counties that haven't allowed licensees in, that there's still, negative sentiment or a negative perception about, licensed cannabis. And then you throw in the proximity to schools, and then now you're kind of like supercharging the conversation, and then all of the people that get hysterical about dispensaries and kids or being too close to kids starts to come out. And so then I don't think the conversation always tends to be one of, that's rational and founded in any logic or actual facts. Because at the end of the day, as Fernando will tell you, like, you can't buy cannabis unless you're 21 years old. You can't come into the store unless you're 21 years old. So, like, there's just no way someone underage can come in and leave with product. And so, and it's ironic because as we all saw, how many illicit shops were literally right in front of schools, right in next to churches, three shops at a time in front of schools, just up and down every avenue of the city, commercial avenue.
Right. In fact, I think, since I do know your store in the neighborhood,
Yeah,
I think there are two illegal shops that are much closer to
they're
the
starting
school.
to pop up again, and they're starting to pop up again.
Yeah.
So-
And look at how easily they're going to be able to close legal ones, but they can't close the illegal ones. The one right across the street from me, they get raided over and over and they stay open.
Yeah. So it's so ridiculous that, but yeah, I mean, we'll see how that if logic prevails, they grandfather it and whatnot, grandfather the ruling by the OCM, that would save a major headache for all parties involved, whether they're dispensary operators, and then also the effect that it will have on the supply chain, which is insane, because there's a lot of big names on that list, a lot of big names, and I think none of us are really that surprised because when you're talking about New York City, everyone's close to a school, everybody's close to a church. It's just the density of the city. It just kind of lends itself to that. So
Right. No, and as we learned in the discussion earlier with a couple of lawyers, this now also includes preschools, daycares, etc.
Well, a lot of buildings that open now open up with a nursery inside them.
Absolutely.
So, it's crazy. And pretty much with all these names on the list, it's pretty much a third of all open operating dispensaries.
Right. And again, the great majority of them are in New York City. So what would you tell the legislature? What happens if there's not a fix to this, or if the fix takes, legislature comes in from January to June? What happens if they get delayed in voting on this?
I don't know, do we sue? Can we sue? I mean, if I commit a crime and I get caught, I pay for it. There's a penalty for breaking a law. These people are publicly stating that 2 laws were broken, but no penalties. We pay the price for their mistake. I don't know. We'll have to see what happens from here to there with our colleagues, people like Alex. But I think there's 8 Daze locations involved in this proximity thing. A again, I don't know how a lawyer can't see that this has no meat on its bones for a case where, okay, we can't operate anymore, but you have to pay your taxes. Taxes that the government, money that the government doesn't observe legally, but they'll gladly take at the end of the year. So I will need some consultation. I don't know, but it's just not right. It's like being on a bus with a drunk driver, right? If I get hit by a city bus, I sue the city, right? I've seen that happen before. Reckless, right? But in this case, the city's like, jump on this bus. And then they put the driver in, and the driver's been drinking all night. Swerving on the road. That's what it feels like.
Alex,
Have to lawyer up, right? At that point.
so what are you guys doing now? What's sort of the plan for the next week, for the next month or two?
I mean, I'm gonna go to that event at Brooklyn Public Library that's hosted by Jeffrey Hoffman. You know, see what what everybody's doing, where the resources are, for us to tap into, and then just see how some of the folks that I know are lawyering up now, how that's gonna play out, because I feel like that's gonna set precedents, going forward, and as far as what we're gonna have to do, and what our expectation in terms of outcomes will be. And so that's the only thing that I can say is that I got lucky that, I just opened. So now, I have a year and 10 months to figure this out. And between now and then, like you said, we're going to have a legislative session that's going to hopefully determine what's going to ultimately happen legislatively. And if it doesn't work in our favor, and we ultimately have to move, then look at what some of the folks that are have attorneys and are, people are going to be suing. All the attorneys are all saying the same thing. There's not even a space where I've seen anybody saying, well, the state has the right to do this, or that we have no recourse whatsoever. Every attorney that I've seen on LinkedIn, and we know all of them, they're just gearing up, and it's gonna be a battle of epic proportions, and so
Now, I did want to reference, there were a couple of articles, lots of articles this week, two in the New York Times, and the last one, the New York Times actually spoke with two of the lead legislators for the Marijuana Regulation Taxation Act, the MRTP. So, Liz Kruger from the Upper West Side, and Crystal People-Stokes from Buffalo. And they both said relatively the same thing, that this is an easy fix, that they had not been consulted. And actually, they themselves believe, and they said, they wrote the law. And they're not quite sure that OCM did make a mistake, right? That in the law they gave them.
I saw that.
Right, you saw they gave them discretion on how to implement. So I wanted to ask, do you think that that OCM, overreacted when they discovered this issue? Maybe overcorrected in the response that they sent out to you guys.
Started to feel that, Fernando, what if this whole thing was sabotage internally by the OCM? That maybe they knew we weren't going to really make all this money.
Customers, we got
Customers, got to let the customer in.
I know exactly.
Sorry.
Customers.
Yeah. So, currently, my wife and I were making more money before than we're making here. And I'm busting my ass here. This is so crazy to me. I wonder if maybe there was some sabotage in the OCM when they saw that people like us, especially in the funds, we're not going to make this generational wealth like everybody talks about. So they did this so in the future we could all sue and see money like maybe we've never seen before. That's how ridiculous. I'm thinking ridiculous Breaking Bad end of the season episode. So that's the outcome, because otherwise none of us are going to make it. And we're all business people. We work hard. Alex with his shop, and, just getting started, and then this gut punch. We were rolling for a year, and this gut punch, thinking that we're under the umbrella of the state, like it's a thing. Like, the state will never hurt us, you know? The state makes laws to protect us. Now look, so it's really hard to think anything in the future. I just, I'm trying to stay calm and work every day and see what happens. I think something good will come out of this. For me. But for everybody else, I don't know. We didn't put money into this. We didn't look for hundreds of thousands of dollars,
Who am I to argue with Crystal Peoples-Stokes? I mean, she knows, procedure and law way better than I'll probably ever understand. And the same thing with Miss Kruger. So I hope they're right. Right. I'm not sure, I can't judge whether or not what they're saying is right or wrong. I hope it is an easy fix. Sounds, I did read the article and I saw the comments that they made. So, again, what am I supposed to say? You know what I mean? Like, I hope so. It feels a lot of people, a lot of trouble, for sure. And a lot of angst. So, it's really, again, I'm fortunate, again, being where I'm at. I know Fernando's in a lot different position that I'm in. And I know a lot of other folks who have licenses that are up for renewal that are, I don't even know what they're going through. Well, I kind of know what they're going through, but not entirely. So,
To close, what would be your message to the governor, if you could speak to her directly?
I don't know. I guess just put yourself in my shoes. I mean, what else can you do? Or ask, like, these we put a lot of time and money and our personal savings, to make this a reality. We're all citizens of this state, citizens of this city. We want the best for this city. We're trying to, follow all the rules and be good neighbors and good operators and, contribute to society as a whole and, do our part. Again, it's a little, it's sometimes, you're lost at words because you're like, who would have ever thought we would be in this position? As hard as everything has been to get here, this is just like such a curveball that it's almost kind of like beyond, words that could kind of, you could get upset, but again, getting upset or, like angry, and I don't know if that solves anything right now, other than now it's like, we're kind of like in survival mode. And it's more like we have to figure something out. But, to the governor, it's just, put yourself in our shoes. We have families. I have 2 kids. The son I'm trying to put through college. I have a 13-year-old daughter is in middle school. We've sacrificed a lot of hours of not being with them to open up these businesses so that we have something to leave behind for them and provide. And if that gets taken away, it's going to be a major blow, to all of us. So, that's all I could say.
Oh, very good. Fernando.
I would say, dear Governor Hochul, here's your chance to be a hero. No. Here's your chance to really do things right. You have to come up with a fix. In our case, we're 491 feet through a block, not on the same street, through a block from a school. From the moment we started operating this, I felt, oh yeah, we are good custodians, great custodians for this emerging cannabis industry. We're the most responsible that you could possibly be. We want to be compliant. We are compliant. We do everything by the book. And if this happens, then you're leaving my wife and I in our mid-50s, burdened with up to potentially $500,000 to $600,000 in federal taxes that we'll have to pay, and God knows what other things going to come down the pipe. How we're going to pay that? This was an opportunity. So, be a hero, figure this out, and in turn, turn our loans into grants, because we can't pay taxes. We can't move forward with this crazy number, or make it fair. I don't know. Figure it out. So far, we've paid $300,000.
All right, Alex and Fernando, just awful story this past week, but I wanted to thank you for taking the time to speak with us today. I want to wish you the best of luck, and I'll be checking in with both of you, and hopefully we'll come back with a good resolution to this.
God will. Hope so.
That's it for this episode of Joint Session Diverse Voices in New York State Cannabis. If you found today's discussion valuable, consider leaving a rating and review on your favorite podcast platform. It helps more listeners find the show. Better yet, share it with colleagues, advocates, and anyone interested in the future of cannabis in New York. Joint Session is produced by me, Herb Barbeau, together with executive producer Robert Curtis from SimLab Media. Special thanks as always to Cannabis Wire. You can follow us on Instagram at jointsession.pod and on LinkedIn at Joint Session Podcast. If you have any comments, questions, or topic suggestions, reach out to me at herb.jointsession@gmail.com. Until next time, this is Herb Barbeau. Thanks for listening.